court calls case number 19-CV-484, Andrew Colborn versus Netflix et al. May I have the appearances, please, starting with the plaintiff?
George Burnett and April Barker, on behalf of the plaintiff, Mr. Colborn, is also present on the call.
And for the defendants?
This is Lita Walker from Ballard Spar on behalf of defendant Netflix, and I believe also on the call is my colleague, Emmy Parsons.
And Kevin Vick on behalf of defendants Crow Media LLC, Laura Ricciardi, and Moira Demos.
And James Friedman from Godfrey & Kahn on behalf of all defendants.
So good morning, everyone. We're here for a scheduling status / scheduling conference in a civil case. I will try to be brief and summarize in the background just to set us up for the morning. This case began on December 17th of 2018 when the plaintiff filed a defamation complaint against Netflix and other defendants in Manitowoc County Circuit Court. The complaint, as I said, primarily alleges defamation claims, and it relates to the Making a Murderer miniseries. The plaintiff filed an amended complaint on March 4th in state court of 2019. The defendants filed a notice of removal on April 3rd of 2019. There were motions to dismiss filed by some of the defendants on service grounds, statute of limitations grounds, and then Netflix also filed a motion to dismiss based on Iqbal Twombly plausibility, fair to state a claim grounds. The court held a hearing on December 19th of 2019. At that time, Netflix's motion to dismiss was denied, and the court concluded that factual issues on the surface required a hearing. The court also granted plaintiff leave to file a second amended complaint. On January 3rd of 2020, the second amended complaint was filed naming Netflix Inc., Chrome Media LLC, Laura Ricciardi, and Moira Demos as defendants. Netflix renewed its motion to dismiss, or filed a new motion to dismiss on March 3rd. The original motion to dismiss on service grounds remained pending. The parties filed an initial Rule 26F report on June 1st of 2020. On September 21st of last year, the case was reassigned to me after I took the bench. We had a couple of status conferences in October and December. The court ordered the parties to mediate. That, I think, took place in March, was unsuccessful. And so the case became ripe for decision. On May 26th, I entered an order granting in part and denying in part the motions to dismiss, basically concluding that the negligence claim failed as a matter of law, but that the other claims were adequately pled and could continue, and that service by publication had been made properly. The defendants filed answers on June 19th, and so we set this for a scheduling conference, and the parties have provided a supplemental Rule 26F report that was filed on July 21st, and I have reviewed that. And so what we're basically here to do today is to set a schedule for moving this case to resolution. Before I do that, let me ask the parties, are there any corrections or updates that anybody wants to bring to the court's attention before we set the schedule? Mr. Burnett?
Nothing, Your Honor.
Counsel for Netflix, Ms. Walker?
No, Your Honor.
And counsel for Chrome?
No, Your Honor.
All right. So, as I said, I've reviewed the updated 26F report and the proposed schedule. And the schedule is basically fine with me. Parties indicate they believe they can get fact discovery completed by April 8th. That's fine. There are expert witness disclosure dates April 29th and May 26th of 2022. Those are fine. I will note that my scheduling order phrases things a little differently. I don't provide a deadline for plaintiff or for defendant. I have deadlines for primary expert reports and rebuttal expert reports, because depending on who has the burden of proof in a particular case, it could be that it's the plaintiff, it could be the defendant, and so I'll use your dates, but the nomenclature will be a little bit different. The parties proposed complete expert discovery by July 26th. That's fine. And then my one question is the parties proposed that summary judgment or dispositive motions be filed by May 13. I'm not sure what the parties are contemplating in terms of expert witnesses, but I wonder whether it would be better to have the dispositive motion deadline after expert discovery is completed. But maybe that's not necessary because the experts won't go to anything that is a summary judgment issue. But let me raise that. Mr. Burnett, is that something the parties have discussed?
I don't think we've discussed it directly, Your Honor, but my suspicion is that summary judgment motions that will be filed will not involve expert opinion.
Ms. Walker?
Yes, Your Honor, that is our thinking.
Mr. Vick, you're in agreement?
Yes, I am, Your Honor.
All right. So then I'll use the May 13 summary judgment dispositive motion deadline. With respect to the final pretrial and trial dates, I'm going to hold off on setting those at this point. Basically, what I'll do is I will wait to see what happens. I mean, I guess I'll be shocked if summary judgment motions aren't filed in this case. But rather than rush, rather than put in pretrial dates and trial dates that may not hold, depending on how complicated the summary judgment motions are, I'm just going to hold off on setting those until after summary judgment is resolved. Does that make sense to everyone?
It does.
Yes, Your Honor.
All right. So that's what I'll enter a scheduling order with all of those dates. Let me also now raise this issue, as the parties know from a prior call we've had. I strongly encouraged everyone to try to settle this case before we even decided the motion to dismiss. And I know that the parties made a good faith effort to mediate in front of Magistrate Judge Duffin, but we're not able to come to an agreement. The court issued a motion to dismiss decision, and I'm now wondering whether would it make sense to revisit mediation either now or either before we get all heavy duty into discovery, or maybe the parties want to wait until after discovery is done. I don't know, but I wanted to at least raise the issue to see if there have been any discussions and if there's any appetite for resuming mediation. Let me also preface this by saying the fact that sometimes it's hard for people to say, for lawyers to say, yeah, mediation might make sense because they think that makes them seem eager to settle. I certainly don't think that's the case, and this is a case that I think, frankly, should settle, as I said before. And so I would like the parties to consider mediation sooner rather than later, but I've ordered it once. I won't order it again unless there is some appetite for it, and perhaps the pending motions to dismiss, the parties wanted to wait for that resolution to happen before they could psychologically or financially move forward with a settlement, but we're past that now. So I'd be hopeful that the parties would be interested in mediating, but if you prefer to wait a little bit longer, that's fine too. With all of that rambling from the court, what are the parties' thoughts with respect to resuming mediation now or later? Mr. Burnett?
Judge, I've been practicing for 40 years, and I have never felt reluctant to pursue settlement early rather than later. So my thinking is that the first step would probably be for Netflix's counsel and Mr. Vick to have a isolated conversation with Judge Duffin. And if Judge Duffin thinks that the further mediation talks would be fruitful now, we're all in. If he thinks that it's unlikely to be any more successful than the last round, then I think we need to wait.
Thank you. Ms. Walker, what are your thoughts on that?
We're happy to have a call with Magistrate Judge Duffin. My instinct is that the parties need to conduct some discovery before this can come even close to a productive mediation. But always happy to talk, and whether it's formal or informal, happy to keep that door open as discovery progresses if the other side wants to talk settlement.
Thank you, Mr. Vick.
Yeah, I concur with what Ms. Walker said.
All right. I will, at this point, I'm not going to order mediation, but I may, if I see Judge Duffin in the hallway, I may ask him what his schedule is in terms of having such a call, and see if he, let me be clear, I do not talk to him about, and he does not convey, he would never convey to me the substance of any discussions or what took place in the mediation. I just know it wasn't successful. But I will see if he's got the time to have a call and thinks that that would be fruitful or useful. I frankly don't want to impose on him and waste his time if that's not something that he thinks would be worthwhile. So I will talk to him, touch base with him, to see whether that's something that would make sense now or in the future. And if he thinks that's worth doing, I may enter a second order setting that requiring that. But for right now, I'm not going to order anything. Let me also just throw out there, obviously you guys are experienced counsel, you're good lawyers. You can talk to one another. You don't need me to force it, and you don't need an ordered mediation to talk amongst yourselves. If at some point in talking amongst yourselves, which I encourage you to do, if at some point you think that a mediation would make sense, file a request on the docket, and I will order it. But for right now, I'll just try to touch base with Judge Duffin in the next week or so and see what his schedule's like and what his appetite for an ex parte call with the defendants would be. And if he thinks that makes sense and he's got the time, I'll enter a separate order. Does that all make sense? And any questions, anything further we need to do this morning? Mr. Burnett?
Nothing, Your Honor.
Your Honor, I'm sorry, April Barker, I'm just going to jump in. If I might, the parties, as a housekeeping matter, the parties have talked about on the call the importance of moving discovery forward. And we have essentially, I think, agreed that the defendants have requested a protective order. We're not, on the plaintiff side, we're not entirely sure what documents are confidential or not because obviously we haven't seen anything and we don't know what's claimed to be confidential. But in the interest of expediting discovery, we're willing to stipulate on the record, if that will help move things forward, that the standard form protective order, the substantive provisions of the Eastern District's protective order could be entered to avoid the need for a stipulation or a motion, if that would be of assistance.
So my only problem with that is that Seventh Circuit law is very, very clear that I can't enter a protective order without good cause. And so I need some sort of factual submission from the parties explaining why there are documents or information that's going to be transmitted in discovery that warrants the confidentiality order or protective order. So I will need something in writing on that. I don't require too much, but there has to be enough of a factual basis that I can exercise my authority to enter a protective order. And like I said, the Seventh Circuit is very clear on that. Those of you that practice in this circuit know that. We used to have just a standing order in the district. This was when I was still a practitioner, not a judge, but in the Seventh Circuit basically whacked the district court judges in this district for doing that. So that's all. That's a long way of responding, saying I'm happy to enter a protective order, but you need to provide something in writing, either a motion or a stipulation, and there has to be facts in that are sufficient to provide good cause for the entry of the order. And the order itself, there's a form on the website that I'm happy to enter. I actually had a hand in drafting that a few years ago.
Understood, Your Honor. Thank you.
All right. Anything further we need to do this morning?
No, Your Honor.
No, Your Honor.
All right. Thank you all. I'll look for the protective order motion or stipulation, and I'll try to get right on it as soon as it gets filed. Good luck, and have a good day.
Thank you very much, Your Honor.
Thank you, Your Honor.